Hello everyone and welcome back to Law Statistics. Today's presentation is based on the topic Muslim Law Part 5th. Gift of Musha, the Hanafi doctrine. The word Musha has been derived from the Arabic word shuya, which literally means confusion. Under Muslim law, Musha signifies an undivided share in a joint property. Musha is thereof a co-owned or joint property. If one of the several owners of the property makes a gift of his own share, there may be a confusion as to which portion or part of the property is to be given to the donee. In other words, there may be practical difficulty in the delivery of possession. If gift of a joint property is made by a donor without partition of the gift share. Also, to avoid any such confusion and difficulty at the stage of delivery of possession, the Hanafi jurists have evolved the principle of Musha, where the subject matter of a gift is co-owned or joint property. The doctrine of Musha is applied for examining the validity of the gift. Under the Hanafi doctrine of Musha, gift of a share in the co-owned property is invalid without partition and actual delivery of that part of the property to the donee. However, if the co-owned property is not capable of partition or division, the doctrine of Musha is inapplicable. Hidayah lays down this doctrine in the following words: a gift of part of thing which is capable of division is not valid unless the said part be divided off and separated from the property of the donor. But a gift of part of an indivisible thing is valid. Musha indivisible. Gift of Musha indivisible is valid. There are certain properties which are by nature indivisible. The physical partition of division of such properties is not practical. Moreover, if against the nature of such properties their partition or division is affected at all, their identity is lost. They do not remain the same properties which they were before the partition. For example, a bathing ghat, a staircase, or a cinema house, etc., are indivisible Musha properties. If on the bank of a river or tank there is bathing ghat, which is in the co-ownership of two or more persons, then each owner has right to deal with his share as he likes, including the right to make a gift of his share. But if a sharer attempts to separate his share, the utility of the ghat would be finished. Where a staircase is co-owned by, say, two persons, then each being the owner of half of the staircase is entitled to make a hiba of his share. Moving ahead. But if the staircase is divided into two parts, it would either be too narrow to be used by anyone, or the upper half may come in the share of one and the remaining lower half in the other share. In both the cases, the staircase would become useless for both of them and also for the donee. The doctrine of Musha is not applicable where the subject matter of gift is indivisible. According to all schools of Muslim law, a gift of Musha indivisible is valid without any partition and actual delivery of possession. Thus, a gift of a share in the business of Turkish bath or a gift of an undivided share in the banks of a tank or river are valid gifts even if made without separating the specific shares. Also, moving ahead, under this is now Musha divisible. Under Hanafi law, gift of Musha divisible property is irregular if made without partition. A co-owned piece of land, house or garden is Musha divisible. The land may be divided and the specific share may be separated by a visible mark of identification. Similarly, a co-owned house may be divided by a partition wall without changing its identity. In other words, a Musha divisible may be divided easily without changing the nature and without affecting the utility of the property. Where the subject matter of hiba is Musha divisible, the Hanafi doctrine of Musha is applicable and the gift is not valid unless the specific share which has been gifted is separated by the donor and is actually given to the donee. Now is the Musha divisible. However, under the Hanafi doctrine of Musha, the gift without partition and actual delivery of possession is merely irregular. The result is that where such a gift has been made, it may be regularized by a subsequent partition and by giving to the donee the actual possession of the specified share of the property. It is evident, therefore, the doctrine of Musha is limited, but in its application as well as in its effect, the operation of the rule is subject to the following limitations. It is not applicable where the property is indivisible. Where the property is divisible, the doctrine is applicable but only under the Hanafi school. Even under the Hanafi school, if a gift is made against the rule of Musha, the gift is not void, it is merely irregular. Hanafi law recognizes certain exceptions to this doctrine, and in those exceptional cases, the gift is valid, though made in violation of this doctrine. Moving ahead, exceptions to the doctrine of Musha. The doctrine of Musha is limited in its application and is subject to certain exceptions where the doctrine is not applicable. Exceptions to the doctrine of Musha are given below. Gift of Musha to co-heirs. Donor and the donee are co-heirs if they are entitled to inherit simultaneously the properties of a person. Gift of undivided property is valid even if made without partition, where donor and donee are co-heirs. If a person dies leaving behind a son, a daughter and the mother, then the son, daughter and mother are all co-heirs as they are entitled to inherit the properties of the deceased. Thus, after the death of a Muslim male, his widow and his daughter are the co-heirs. Therefore, the widow can make a lawful gift of her undivided share in the land to her daughter without separating her share physically. In Mahmood Buksh versus Hosini Bibi, a Hanafi woman died leaving her mother, son and daughter as her only heirs. The mother of the deceased made a gift of her share to the son without separating her one-sixth share in the properties of the deceased. It was held by the Privy Council that the gift of the undivided one-sixth share by grandmother to her grandson or to the granddaughter or to both jointly was valid even without partition. Even gift of share in zamindari, where a part of the erstwhile zamindari or taluka was gifted away by one of its co-sharers, the doctrine of Musha was not applicable. In the zamindari systems, it was possible that two or more persons were the co-sharers, having their definite shares of which they used to be respective owners. If any of them made a gift of his share, the gift was valid without actual delivery of the possession and without physical partition. Now is the gift of share in landed company. The Hanafi doctrine of Musha originated with an object of avoiding confusion at the stage of taking the possession by donee. In the landed company or big commercial establishment, where the ownership consists of several definite shares, gift of a share by separating the share physically from the rest would create confusion and inconvenience, and this would be against the very purpose of the doctrine. Therefore, in such cases, the doctrine is inapplicable. In the case of Ibrahim Ghulam Arif versus Saibu, the donor owned a large number of shares in 6 limited liability companies together with several pieces of freehold land and some buildings thereon in Rangoon. He notionally divided the whole property into 1000 shares and made a gift of 100 such shares, each to 4 donees, and also 25 such shares, each to the other 2 donees. Moving ahead, the whole property could be inconveniently though physically partitioned from the rest, but no such partition was made by the donor. It was held by the court that the gift was valid without actual division because the property was not conveniently divisible. The court further observed that it would be inconsistent to apply the doctrine of Musha to shares in the companies because the doctrine originated for very difficult kind of properties. Gift of share in freehold property in commercial town. Where a freehold landed property situates in commercial town or in big cities, its frequent partition is disfavored. In big cities, the houses are well planned and the partition may require approval of a fresh map which may take considerable time. Therefore, where a part of such property is gifted, the gift is complete without any prior partition. Gift of a part of a house situated in Rangoon was held valid without prior partition because the house was situated in large commercial town. Similarly, it has been held that the doctrine of Musha has no application in commercial towns like Lahore, Bombay or Calcutta. Device to overcome the doctrine of Musha. The Hanafi doctrine of Musha is applicable only to gifts. It is not applicable to any other kind of transfer, example, sale, exchange, etc. We have already seen that the strict application of the doctrine invalidates the gifts of co owned properties and operates disadvantageously in most of such cases. Because of this reason, the Hanafi jurists themselves have evolved a method by which the mischief of the doctrine is avoided. The device to overcome the doctrine of Musha is simple. The donor may sell the undivided share without any prior partition and may return the consideration immediately to the donee. Legally, this transaction would be a sale in which the doctrine is not applicable, but in effect it would mean a gift. Doctrines of Musha in present society. In the present Indian society, the doctrine of Musha is neither legally required nor has any practical significance. As mentioned earlier, the doctrine of Musha originated for avoiding confusion in the simple cases of the gifts of small undivided properties. In the old days, no such technical formalities were needed in making divisions of the joint properties as are required today. But at present, instead of avoiding the confusion, the application of the doctrine may create inconvenience and complications. In the present commercially advanced society, the Musha doctrine may operate as a restriction upon the right of a person to deal with his properties. Gifts are not trade oriented transactions, they are voluntary and gratuitous transfers. Therefore, the gift should be free from as much restrictions as possible. Moreover, where a constructive delivery of possession is sufficient to complete the gift, there is no need of making actual division. A symbolic possession by the donee of the gift share is in property validates the gift. In Masood Sab vs. Madan Sab, the Andhra Pradesh High Court held that a gift of Musha is not invalid if the donor makes a constructive delivery of the possession. Therefore, there is no legal difficulty if the Musha doctrine is applied to a gift of an undivided property. This device to avoid the Musha rule have been favored by the courts. In the case of Sheikh Muhammad Mumtaz vs. Zubeda Jain, the Privy Council too had observed that the doctrine of Musha is unadaptable to progressive state of society and would be legally necessary not practically meaningful for the present society. That's all for the presentation. Thank you and have a great day ahead.